Thank you, Julian. Thank you, Filippo, for your excellent speech. And thank you also because your firm will sponsor the coffee break that we are going to have after, say, 15 minutes. We have, another distinguished speaker before the coffee break, and we listen, how to handle with major casualties. And now we have Francesco Siccardi from Studio Legale Siccardi Bregante, a qualified lawyer since 1966, and since 79, senior partner of this firm. I leave the floor to Francesco, who will basically tell us, what about safer ships and what is the marine underwriter's role?
Thank you, Mauro. Good morning, everybody. When I was asked to make a presentation by Francesco, I had to decide whether I would keep awake the Italian delegates or the English delegates. So I decided to go for English slides and Italian presentation. But last night, I was recommended to shift on to English for the presentation. So I will go online. Sorry for this English, which will be even more broken than it is normally. Underwriters are big players in the shipping arena. Not only, of course, property underwriters, also, obviously, liability underwriters. Push. There is a list of those functions which the underwriters in general have in the shipping arena. As you can see, they have a function of protection of the owner, both protection of the specific asset or the corporate assets, have a function in the ship financing, and have a function in contributing to safety through participation to the implementation process of the safety rules. But let's go to the topics of this presentation, which is casualties, in which they have even more importance because the underwriters are heavily hit by I think here the underwriters play even a more important role in two different functions. One is prevention. Prevention of casualties can be achieved by underwriters, to me, through these three possible avenues. One is assessment of the risk through condition surveys or similar activities. The second one is prudent underwriting policy. This is not the same thing as making assessment. It is also keeping premiums at adequate level to keep the loss ratio to tolerable limits. I think that the IUMI recent conference in San Diego has approached this aspect. Morelli will tell us about that, I think. And third, of course, is taking part in IMO or other, within other bodies to the implementation of safety rules. The second function is in the settlement of claims. Why? Why? Because the underwriters have the possibility to condition payment of indemnity to compliance with certain safety rules, rules which are incorporated as conditions of the policy. The presentation is about this quite quickly as possible, given the time constraint. Well, there are, in fact, on a systematic approach, there are two kinds of rules which the underwriters, and I'm now taking basically property underwriters, have or can apply. One is what I call cover exclusions, and the other one are what I call condition precedents or warranties. The difference is quite distinct. In the first case, the underwriters do not pay if by the conduct which represents an exclusion, the loss was caused. So causation enters into play. In warranties or conditions precedent, causation doesn't enter into play. If there is no compliance with the warranty, the underwriters are discharged irrespective of whether or not the casualty was brought about by that non-compliance. In the first category, the cover exclusions, I have selected two kinds of conduct. And I have also spoken of dual threshold, because there is in fact a difference. Whether the assured conduct in general is in play, or whether the assured conduct interfering with the vessel's employment is in play. In the first case, the assured conduct in general, the level of diligence which is required to the assured is not very high. Only in case of willful misconduct, the underwriter is discharged. And the willful misconduct you will see in the slide is defined as an act intentionally done or deliberate omission by the assured, with knowledge that the performance or omission will probably result in injury, or an act done or omitted in such a way as to allow an inference of a reckless disregard of the probable consequences. Is something more than gross negligence, is what we call dolo, or something more than colpa grave in Italian. And these are rules which apply also to clubs, as you can see, which apply the Norwegian Marine Insurance Plan or the French hull policy. Whilst the negligence, the ordinary negligence, and even the gross negligence is covered. But if we go to the assured conduct interfering with the use of the vessel, employment of the vessel, then the threshold is higher. The level of diligence required is higher. The assured or the underwriter is discharged if there is the privity of the assured. And the privity has been defined in 1976 as the knowledge and consent to the unseaworthiness conditions. And then a second rule is that the master negligence, the pilot negligence, the crew negligence is covered, provided there is no want of due diligence by the assured. Due diligence is the ordinary diligence. Therefore, the fault, the simple fault, can be sanctioned. And something similar, as you can see, is provided for in the Italian navigation code. If we go to the second category, the warranties, well, the warranties have been introduced as a rule in the standard form in 1983. The classification clause was already in the market, but it was incorporated in the standard clauses in 1983 and required that the vessel must be classed, no change of suspension or withdrawal of class, non-compliance, there it is the difference, termination of cover. The underwriter doesn't need to say the loss was caused because the vessel wasn't classed. The underwriters may simply say, you were not classed. Now, very briefly, how have these rules changed? Safety rules have become stricter under many respects. Let's simply think about SOLAS implementation of new rules, the ISM, the EU directive after the ERICA, and so forth. Have the underwriters followed that? Have the underwriters go along the same trend? Well, I'm a little bit doubtful about this. Let's look at how an English court has defined privity in 2003, 26 years after the Eurysthenes, the 1976. To me, but there are distinguished English lawyers here, and they may say something against what I'm saying, it seems to me that privity has been construed to be stricter and therefore more in favor of the assured than it was before. Because the court in the Star Sea said, you assured have to have a suspicion or belief that the vessel was unseaworthy and deliberately refrain from making inquiries. So the level of conduct seems to be less strict than it was in the interpretation as I read it in the Eurysthenes. And also, the other example is the question of the due diligence. The due diligence in 1993 was the due diligence of the assured, the owners or managers. Obviously, assured means also the alter ego of the assured. But alter ego is something like board of directors or similar situation, except maybe in the US, where there is a wider construction. In 1995, it was extended to onshore management, superintendents, fleet managers, or similar people having managerial duties. In 2003, the international hull clauses, which nobody applies, incidentally, it has been deleted. So the due diligence remains the due diligence of the assured, the owners, or managers. And let's go to the warranties. Here, the difference is due to the fact not simply of a market reaction, but a question of principle. The jurists have started to question whether the warranties should remain as a principle because they are a too draconian sanction, at least as they are ruled in the Marine Insurance Act 1906. And therefore, the market has, on one hand, extended the contents of what was warranty, but at the same time shifted from warranty to cover exclusions. And this is shown here. You can see that class, which was only class and no withdrawal, has become also compliance with recommendations imposed by classes to vessel seaworthiness to be complied with at a due date. And obviously, with the introduction of the ISM, the DOC SMC certification has been required. And then a new rule has been introduced about management, and it says, duty of the assured owners managers to comply with statutory requirements regarding, for example, equipment, operation or manning, STCW, for example. And same rules are followed by other standard forms. But the non-compliance is not termination of cover as before, is loss caused thereby not covered. Therefore, you need to show that it is the non-compliance who has caused the loss to avoid payment of the indemnity if you are an underwriter. And this leads me to the conclusion, which I put in terms of questions for the audience if someone wants to discuss them. Are underwriters reluctant to apply too strictly the rules? Is the market not prepared to accept restriction of cover? The fact that the IHC 2003 conditions have not been adopted yet is an example of this, maybe. And therefore, how effective is the role of marine underwriters in promoting safety? Thank you very much.